In this video, I'd like to talk about the document for incapacity that allows someone to deal with your financial affairs. This document is the Iowa Statutory Power of Attorney. This form was revised in 2014 based upon the Uniform Power of Attorneys Act. This is an act that many states have adopted in an effort to have a uniform law regarding powers of attorney. The situation it applies is similar to the situation when the healthcare power of attorney applies. I have been in some type of accident or I have a condition that prevents me from communicating my wishes or processing the information so that I have a clear picture of what my condition is. There is no court supervision. The purpose of this is specifically so that I can appoint someone to make decisions on my behalf without the court becoming involved. The key provisions of this document is that it allows me to appoint an agent and an alternate, grant them general authority to deal with a wide variety of issues, also grant them specific authority on certain issues. These issues may be to amend my other documents, it may be to make gifts of my property, to disclaim property. In general, anything that I could do with my own property, it allows them to do. The default provisions under the Iowa statute are that this is effective immediately. It does not spring into existence at some future date upon the occurrence of some other event. This was how we had typically drafted these powers of attorney. They sprang into existence only when a physician declared that I was incompetent. Prior to that time, they were just pieces of paper sitting on a shelf. If you name more than one agent, majority rule is the guiding principle. The power of attorney specifically addresses reimbursement of expenses, but it does not address compensation specifically unless you choose to include that as a part of the document. It also allows for special instructions should you want to include specific instructions of what to do. There's a description of what the agent's duties are and how they should conduct their affairs. And it also addresses how the power of attorney is terminated. There is a discussion of the liability of the agent for wrong decisions, and the standard here is really one of reasonableness and acting in good faith. When it is signed, it needs to be witnessed by two individuals or notarized. And there are instructions again with respect to the document. Then when something happens, the agent is notified that you have become incapacitated, and then they file an agent's certificate in the county courthouse, letting the rest of the world know that they are making financial decisions on your behalf. One of the points that people often forget and causes a lot of confusion and frustration is that the power of attorney terminates at the moment of death. Prior to death, you have full power and authority to handle someone's affairs, but at the moment of death, that authority terminates in its entirety. At that stage, either an executorship, an administrator, or a trustee takes over with respect to the property.